In 1773, an English village called Rons lost its commons in a single parliamentary session. Families who had grazed cattle, cut timber, and fed children from that land for generations found it fenced off within months. The act was 3 pages long. The dispossession was permanent. That is not ancient history. That is the template. Between 1604 and 1914, the British Parliament passed more than 5,200 individual Enclosure Acts. Each one transferred land that communities had used collectively for centuries into private hands, legally, procedurally, with full institutional blessing. By the time the process was complete, an estimated 21% of England's total land area had changed ownership. The people who depended on it did not receive compensation. They received vagrancy laws. You are watching a version of that process right now, in 2021 and 2022. Institutional investors, Blackstone, Invitation Homes, American Residential Properties, and dozens of smaller vehicles purchased single-family homes at a pace that individual buyers could not match. In some U.S. metro markets, investor purchases accounted for more than 30% of all transactions in a single quarter. The mechanisms are different. The outcome is structurally identical. Ownership concentrating upward. Access converting into tenancy. The baseline security of property transferring from the many to the few. By the end of this video, you will understand the exact legal and financial mechanism behind both enclosures, the 18th century version and the one currently running. You will understand why it works, who it serves, and what the forensic record says about the only response that has ever actually worked. This is not a conspiracy. It is a pattern. It has a name, a documented history, and a repeating logic that does not require malice to function, only incentive. And incentive is not hard to find when independence makes labor expensive. To understand what was taken, you have to understand what existed before. The commons were not empty land. They were not wasteland, waiting to be improved. They were a functioning economic system, informal, decentralized, and extraordinarily resilient, that had operated across England for centuries before Parliament began dismantling it. A commoner's family did not need wages to survive. They needed access to the common pasture. A family could keep 2 or 3 animals, a cow, some sheep, a pig, without owning a single acre of titled land. The milk fed children. The wool was sold or traded. The pig was slaughtered in autumn and salted through winter. Access to the common woodland meant timber for heat and repair, and forage for the animals in lean months. Access to the common meadow meant hay for winter fodder, cut collectively under rules the community itself administered and enforced. This was not poverty. This was a parallel economy, one that sat beneath the money economy and insulated ordinary families from its worst shocks. A bad harvest raised grain prices, but a family with common rights still had milk, still had meat, still had fuel. The commons functioned as a biological buffer against market volatility. And that buffer is exactly what made the system, from the perspective of the emerging industrial economy, intolerable. Here is the logic the landowners understood before the peasants did. If a man can feed his family from the forest, why would he work in your factory for pennies? He would not, and he did not. Throughout the early 18th century, English landowners and nascent industrialists faced the same structural problem. Labor was not cheap enough. Not because workers were protected by law. They were not. But because workers retained an exit option. The commons meant that wage labor was a choice, not a necessity. A man who could feed his family without a wage could refuse a bad wage. He could wait. He could negotiate, however informally, from a position of minimal security. Arthur Young, the agricultural surveyor who traveled England between 1768 and 1771 and documented commons economies in detail, wrote that in parishes with intact common rights, he consistently found a class of people enjoying a modest but genuine independence. He did not mean comfort. He meant the specific economic condition of not needing a wage to survive the winter. That security was the target. The Enclosure Acts were not primarily a land policy. They were a labor policy. The land was the mechanism. The dispossession of exit options was the goal. Once the commons were gone, the factory gates became the only door open. What followed was not accidental. It was arithmetic. The dispossession did not happen by force. That is the detail most people miss. No army marched into the commons. No royal decree abolished customary rights overnight. The Enclosure Acts worked precisely because they used the most legitimate instrument available to 18th century England, Parliament itself. Each act was debated, drafted, voted upon, and recorded. The process looked like governance. It functioned like confiscation. Here's the mechanism in its exact form. A landowner, typically a large estate holder with existing parliamentary connections, would petition for an Enclosure Act covering a specific parish or common. A commission would be appointed to survey the land and apportion it. The commission was not neutral. Its members were almost always drawn from the same propertied class as the petitioner. Commoners, whose families had exercised usage rights for generations, were invited to submit claims, in writing, in legal language, before a body that had no structural interest in recognizing them. Most commoners could not write. Many could not read. Almost none had documentary evidence of rights that had been exercised by custom and memory rather than recorded deed. The commission ruled. The fences went up. The act was entered into the parliamentary record. Between 1604 and 1914, this process repeated 5,200 times. Each act covered a specific geography, a parish, a common, a stretch of fenland or moorland, and each transferred that geography from collective customary use into private titled ownership. The cumulative result, approximately 6-8 million acres enclosed. Roughly 21% of England's total land area redistributed upward through a legal process that was technically open to challenge and practically impossible to contest. The speed accelerated as the industrial demand for labor intensified. Between 1750 and 1850 alone, the century that built the factories, Parliament passed more than 4,000 individual acts. That is an average of 40 per year. In peak decades, the rate was higher. The legal infrastructure of dispossession was running faster than most villages could track. One more detail. The official history tends to omit the costs of enclosure, the surveying, the legal fees, the commissioner payments, the fencing itself. When the fences went up, the people did not disappear. They moved, not by choice, not toward opportunity. They moved because the alternative was starvation and because a set of laws passed in the same parliamentary sessions that authorized enclosure made staying in place a criminal offense. The vagrancy acts were the second half of the mechanism. Once common rights were extinguished, a family without land and without a wage was legally classified as vagrant. Vagrancy was not a misdemeanor. It was a status point, one that could result in whipping, forced labor, transportation, or impressment. The Enclosure Acts removed the exit option. The Vagrancy Acts criminalized remaining in place without one. The only legal direction was toward the factory towns. What they found there was not opportunity. It was the other end of the arithmetic. Manchester in 1800 was a city of approximately 25,000 people. By 1850, it held more than 300,000. That rate of expansion did not produce housing. It produced density. Courts and cellars and back-to-back terraces where families of 6 shared a single room, where open sewers ran beneath sleeping quarters, where child mortality in the poorest districts exceeded 50% before age 5. Ingalls documented this in forensic detail in 1845, not as polemic, but as reportage. He walked the districts. He recorded the dimensions of rooms, the contents of diets, the distances workers traveled before dawn to reach the mills. The picture that emerges is not of poverty as misfortune. It is of poverty as infrastructure. The slum was not a failure of the industrial system. It was a feature of it: dense, desperate, dependent labor. Stripped of land, stripped of exit, stripped of the commons that had once made independence possible, was exactly what the factory economy required. This is the part that the standard economic history tends to frame as transition. The movement from agricultural commons to industrial wage labor is usually narrated as modernization. Painful, perhaps, but ultimately progressive. The forensic record suggests something colder. It was not a transition. It was a transfer. Wealth moved upward. Security moved downward. The language of improvement covered the arithmetic of extraction, and the people who lost the most had no parliamentary voice to name what had happened to them. They had only the memory of what the commons had once provided, and the daily reality of what its absence now cost were frequently charged back to the commoners being dispossessed. Families who lost their land also received a bill for the process that took it. In some parishes, small freeholders who technically received an allotment under the Enclosure Award could not afford the fencing costs the act required them to bear. They sold, usually to the same estate that it petitioned for enclosure in the first place. The arithmetic closed perfectly. Those who designed the system understood that legality and justice are not the same thing. They used one to defeat the other, at scale over 3 centuries, with full institutional endorsement. That is the template. The commons this time are not fields. They are neighborhoods. The mechanism is not parliamentary acts. It is capital structure, the ability to close in cash at scale faster than any individual buyer can compete. In markets where the target asset is the single-family home, that has historically been the primary vehicle for middle-class wealth accumulation in the United States. The numbers entered the public record starting around 2012, after the foreclosure crisis had depressed home prices to levels that made bulk acquisition mathematically attractive. Invitation Homes, backed initially by Blackstone, purchased approximately 80,000 single-family homes across American suburbs, not apartment buildings, not commercial real estate. Individual houses in individual neighborhoods at a pace that individual families could not match, because individual families cannot wire $400,000 in cash before an inspection period closes. By 2022, institutional investors, defined as entities purchasing 10 or more properties, accounted for somewhere between 25% and 30% of all single-family home purchases in the highest target metro markets: Atlanta, Phoenix, Charlotte, Dallas, Sunbelt cities where population growth created demand that zoning restrictions constrained, producing exactly the supply squeeze that makes bulk acquisition most profitable. The parallel to enclosure is not rhetorical. It is structural. In 18th century England, the mechanism depended on 3 things: a legal instrument that concentrated ownership, a financial advantage that made resistance impractical, and a policy environment that enabled rather than restricted the consolidation. The Enclosure Acts were the legal instrument. The estate system provided the capital advantage. Parliament provided the policy environment. In the 21st century, the legal instrument is the LLC structure and the 1031 exchange, which allow institutional buyers to defer taxes on gains rolled into new acquisitions indefinitely. The capital city felt fear. Something military. The United States military, and shocking, was unable to carry individual buyers. The policy environment is zoning law, specifically single-family zoning in high-demand areas that restricts new supply while doing nothing to restrict bulk acquisition of existing stock. The commoner in 1780 could not afford the fencing costs the Enclosure Act imposed. The first-generation home buyer in 2022 could not compete with an all-cash institutional offer that waived inspection and closed in 7 days. Different century, different paperwork, identical arithmetic. There is one difference worth naming honestly. The 18th century enclosure needed parliamentary approval, a public process, however, captured. The 21st century version needs no such approval. It needs only capital, legal structure, and a policy environment that has not yet decided whether ownership concentration in residential real estate is a problem worth restricting. That decision is still pending, which means the window for the individual response is still open. The forensic record across every enclosure-style event in history produces one consistent finding. The families who retained ownership through the consolidation wave were not the ones who protested loudest. They were not the ones who waited for the policy environment to correct. They were the ones who acquired clear, productive, titled property before the window closed, and structured that ownership in ways that made institutional encroachment legally and financially unattractive. That is the protocol. It has 4 components. First, productive over prestige. The asset that survives consolidation is not the most valuable property in the most desirable location. It is the property that produces something independently of market conditions: food, water, energy, timber. A suburban house in a hot market is a speculation. A modest parcel with water rights, tillable soil, and legal access is a position. The common survivor's history remembers were not the wealthiest. They were the most self-sufficient. Second, title clarity before acquisition. The enclosure commissioners defeated most common right claims not through superior argument but through documentation asymmetry. The landowner had deeds. The commoner had memory. In any future consolidation scenario, whether driven by institutional acquisition, tax lien accumulation, or eminent domain expansion, the first line of defense is unambiguous recorded title, held in a structure that does not make you an easy target. An LLC with a single asset and clean chain of title is harder to dislodge than a personally held property with encumbrances, disputed boundaries, or deferred tax obligations. Third, physical productivity over paper appreciation. A property that produces measurable output, crop yield, rental income, energy generation, has a defensible value independent of comparable sales. Comparable sales can be manipulated by bulk acquisition. Documented productive capacity is harder to argue away in any legal or administrative proceeding. Fourth, community of title. The commons survived as long as it did not because individuals defended it, but because communities administered it collectively under shared rules. The modern equivalent is not a commune. It is a small number of aligned families holding adjacent or nearby productive parcels under separate clear titles, with documented mutual access agreements and shared infrastructure investments. Institutional buyers target isolated assets. Clusters of coordinated ownership are significantly more expensive to consolidate. The 18th century commoner had no warning, no forensic record to consult, no pattern to recognize. You have all 3. The binary choice at the center of this record is the same one it has always been. You can wait for the policy environment to protect you and discover, as the commoners of Rons discovered in 1773, that the policy environment was never designed with your ownership in mind, or you can acquire your position before the next act passes, title it cleanly, make it productive, and become the kind of asset that institutional arithmetic finds more expensive to absorb than to ignore. One approach waits for the commons to be defended. The other builds a new one.